sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. If you follow all of these and do everything that you're supposed to, this is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence that you've already agreed to. Do you understand?
Mm-hmm.
I don't see the certification attached to this one. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Macon. All right. Good luck to you, sir. You can go back with the bailiff.
I'll be able to see you, Jeff.
See, Ms. Delays, you've got Howard Walker Jr.
Yes, Your Honor.
Morning. Morning.
So you say. Way down the road. Right here, Mr. Walker.
Good morning. You're Howard Walker Jr.
Yes, ma'am.
This is 26 DCCR 0082. Mr. Walker's charged with injury to a child, elderly, or disabled individual. It's a first-degree felony. What is the announcement?
Your Honor, we'd like to ask for one more reset. I've just gotten all of the discovery. Need to go to the jail and go through it with him. I think Luke, Mr. Nichols agrees with me on this because he's got his.
I know they had to copy a lot of media.
Okay.
And so it's ready, and I think she either has it or.
I have it,
So,
but I haven't gotten to show him, and I've only gotten about halfway through it.
Okay.
Quite a bit.
So we'll do one last reset. And so between now and that next court date, Ms. Delays, you'll be out to the jail to go over everything, show you everything that she's received. And then we'll get an announcement at that next court date after you see everything, if you still want to go to trial or if there's some agreement that gets worked out. Okay. All right. We'll see you at the next court date.
Thank you.
Thank you. Yes, ma'am. Say, Mr. Wilkerson, you've got Bradford Josie.
Yes.
Bradford Josie.
Good morning. Look at you doing your certificate. So there's no agreement. We're just going to go through the motion.
Yes, sir.
Okay.
It's going to play true to 33.
Okay. I'll go through all of them and we'll figure out what we need to do. Good morning, sir. You Bradford Josie?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the motion?
Yes, ma'am.
Mr. Josie, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And in cause number 25, DCCR 1062, I have a motion to revoke your community supervision. Shows that you were placed on probation October 14th of 2025 for the state jail felony offense of burglary of a building. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count one alleges that you committed the new offense of evading arrest, a Class A misdemeanor, February 22nd of 2026 in Jefferson County. And is that true or not true?
That's true.
Count two, bless you. Are we changing? Are we
I'm playing not true to first and second.
okay?
I'm sorry, I didn't understand.
Count two alleges that you committed the offense of burglary of a vehicle March 9th of 2026 in Jefferson County, Texas. And is that true or not true?
Gotcha.
Count three alleges that you failed to report to the probation office as directed November 18th and December 11th of 2025, and then January 6th of 2026. And is that true or not true?
True.
Count four alleges that you failed to report to the probation office for your administrative hearing on February 12th of 2026. And is that true or not true?
It's true.
Count five alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
That's true.
Count six alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count seven alleges that you were at a location other than your residence at approximately 3:25 a.m. on March 9th of 2026. And is that true or not true?
That's true.
Count eight alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
That's true.
And then count nine alleges that as of February 12th of 2026, you were $700 behind in your court assessed fees. Is that true or not true?
Yes, ma'am, it's true.
Did you enter your pleas of true to counts 3 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Now, I don't want to get into, I'm not asking any questions, but with regard to counts 1 and 2, I do want to make everyone aware that if we come here and there's a hearing and you act, I don't want us to have to come and have a hearing, have officers come if in fact there's something that is blatantly true. It's not going to help you if you're not taking responsibility.
Yes.
If you actually didn't do it, that's fine. That's what the hearing's for. But just to not take responsibility doesn't sit well. Does that make sense?
Yes, ma'am.
All right. So are we good with what we played on then?
Yes, ma'am.
Okay. Then I'm going to find that you entered your pleas of true to counts 3 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I am going to reset your case for a hearing so that the state can bring witnesses with regard to counts 1 and 2. We'll get an updated pre-sentence report done. And I'm guessing
Not long, Judge.
not long, so maybe even on 11 o'clock.
Yes, ma'am.
Okay, so we'll set it on a regular docket date at 11 so we can have any witnesses. Anything that you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me on your behalf when we come back.
And just for the court's information, Judge, once we have those underlying issues dealt with down the hall, then those pleas will change. So it's I'm just giving you a heads up because if we set it for a hearing right now today and we're able to get those dealt with beforehand, then we're subpoenaing witnesses when a hearing wouldn't be.
Well, that's why I'm saying I don't want to do that. So if they're true, they're true. I don't want to, I mean, if you need time to take care of something, that's one thing, but to stand and swear under oath that something's true or not true is putting Mr. Josie in a position of, I don't know what you mean by taking care of them, but if he's going to go plea on some cases down the hall and he just said under oath that it's not true, then we have an issue.
I would like to establish on my square morale.
Hold on. I want you to talk to Mr. Wilkerson. Let's figure out the timing of all this because I don't want to do it this way, if that makes sense.
I understand.
So, I don't want him to have to subpoena witnesses. I don't want to get close and then we keep doing this and we show up and then there's some deal that's made and we've got officers who either just got off a night or whatever that had no reason to have to be here. So, I've taken the pleas. I'm going to reset it at this point for a sentencing hearing. However, I want to know within at least a week before that hearing. If I want Mr. Coleman to know if he has to get those witnesses here.
Yeah.
So at least 7 days. Okay. All right. You can go back with the bailiff.
Thank you.
Thanks, Tiff.
Thank you, Your Honor.
Yes, sir. We're gonna set for that and then we're gonna hopefully hear what we need to, or I'm gonna be very excited. Sir Samuel, are you ready on Eric Hebert?
Yes. I'm ready to ask for. Yes.
Yes. Ashley, Eric Hebert, yes. I don't know what's happening.
Yes, Eric.
What Hebert says. Eric Hebert. Okay, thanks.
Come on.
Good morning. Morning. Here we go. Good morning. Very long. Good morning. Are you Eric Hebert?
Yes, ma'am.
And this, we've got two cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may, he has a new DWI third. I've spoken with this officer, Ms. Kane, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, you can go with the new case outstanding. Obviously, the new case I will not dismiss. And obviously, the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
Oh, that's the agreement with the defense. Yeah.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks I've.
Well, that's going to be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's going to take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
Right.
Agreement.
agreement.
No agreement. So it's just what you guys obviously
it was
would
just
recommend. Sure. So do we want to go through the motion today then?
We can,
Or,
I'd rather have which one would expedite the,
A plea would, because I could push it without the lap, but if if, in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
All right. We'll just
Let's do
reset. I'll
that.
just do a normal reset.
Thank
Y'all
you,
see if y'all can get that taken care of.
Yes,
All
ma'am.
right, and go back with the bailiff. Darrell Lee, oh, she's not over there. Darrell Lee is being dismissed, so he can be taken back. Yes, I'm signing that now. Let's take care of Mr. Parker. Can we take care of Isis Martin?
Okay.
Isis Martin.
You need my file inspection.
Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the plea?
Yes, Mr.
I'm sorry?
Should have no criminal history. This is only arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go to straight there, you also run the risk of me not accepting the plea agreement. Do you understand that as well?
Yes, ma'am.
And then also a condition of your bond is that you have absolutely no contact or communication with Harmony Bodner. That obviously means in person, but it means any other way as well. So you can't send messages through other people. You can't send messages on your phone, by text or Snapchat or whatever else exists out there. Do you understand?
Yes, ma'am.
Do y'all live anywhere close to each other?
No.
Okay, so there's no reason for you to have any contact with her. So you need to show me between now and when you come back that you can do everything you're supposed to, so I don't have any issues with putting you on that probation, okay?
Yes, ma'am.
All right, we'll see you back at sentencing. Hector Wiggins, Mr. Parker.
Hector Wiggins.
Substance abuse, 14 is fine. Okay. I do with it.
And everybody knows that we reset rapid page time. Bailiffs. So that we could do it after that co-defendant.
Oh, okay. I'm sorry. I was just going on your email that you wanted to bring.
No, so this morning he came and talked to me.
Oh, okay. That makes sense. That's all I need.
He had talked to you. Jacorian Flemings is getting reset.
It's needed to talk to him, so that's good.
Okay. All right, sir. Are you Hector Wiggins Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Wiggins, in clause number 24, DCCR 0548, you're charged with a state jail felony offense of theft of property with previous convictions. And that's from November 4th of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Your indictment also alleges you were previously convicted of theft, July 14th of 2022 in Montgomery County, Texas. 2 cases on that day, September 9th of 2022 in Montgomery County, February 27th of 2023 in Harris County, and 2 cases on that date in Harris County. And are all those prior convictions true?
Yes, ma'am.
Did you enter your plea of true also to those freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So what is the, what are those latest? The 22 and 23 cases, some punishments on those?
Got to figure I've got something for you, Judge. I just seen it. He's on vigils now.
That's what I figured just based on the counties. Thank you. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Wiggins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of property with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so, Mr. Wiggins, you've done a whole lot in the last few years with regard to thefts. And I want to make sure you understand that if you're back in Jefferson County and you commit a theft again, it's not going to go this well. You now have enough prior cases to where you probably could be enhanced potentially to a 3rd-degree felony and go to TDC for up to 10 years. So you're okay this time. You got your deal. I went along with it. But if you continue to do that, it's just going to get worse and worse every single time. Do you understand?
Yes, ma'am.
All right, and go back with the bailiff.
And Your Honor, we've emailed the attachment.
Okay.
Discovery.
Thank you.
I have 2 of them I didn't have.
Thank you. Brent Smith.
Can you hold on that,
Yeah.
Judge? I haven't got him signed up. I've got it. In the covers and that was but I just got.
Let's take care of Jesus Garcia, Mr. Parker, since it's ready, and then I'll give you a minute to work on the rest of them.
You call me?
Jesus Garcia, so let's go ahead and do that one, and then I'll
Okay.
give you a break
This
to
is
take care
another
of
one
it.
that I don't have. We've already emailed the discovery
Thank
attachment.
you.
We've always had it in my file and they're not there.
And is he pleading on just one of these?
Yeah, pleading on the firearm, just
Okay.
missing the other.
Thank you.
This one, Judge, and just so you know, the court, we brought him down here from Minnesota. He's also serving time up there. He wanted to come back and resolve these.
Okay.
That's
Perfect.
the
Thank
reason
you.
to try to wrap them all up today.
Thank you. All right, sir. Are you Jesus Marin Garcia? And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Garcia, in cause number 24 DCCR 0586, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon, and that's from July 14th of 2023. How do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Speak up, please.
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Marin Garcia is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal when it comes through in cause number 24 DCCR 0587 as part of this agreement. It will also run concurrently with any case that you're currently serving in Minnesota as well. All right. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required by law to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can ask Mr. Parker. All right. Good luck to you, sir. Thank you.
Judge, I think they filed a motion to dismiss it on Lee. I don't know if you got it.
I already signed it and I already told them that
Okay.
they could let him go back. Thank you. And I'll sign, don't forget to send Garcia's, thank you.
It's already been emailed.
I meant to just,
Oh.
Yeah.
Okay.
but that too, thank you. See, Mr. Rojas, you've got Byron Morris. Byron Morris,
He's.
are you doing paperwork?
Yeah.
Okay, I don't have it yet. I'll hold it.
He hasn't been printed yet. I don't.
Let's see, who do you have that's ready?
Hold off on him.
How about, let's do Destiny Vargas, please. Morning.
Good morning.
Are we going on count one?
Yeah.
Good morning, ma'am. Are you Destiny Vargas? And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Vargas, in cause number 26 DCCR 0081, the state has elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, it is.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back to the bailiff. Quentin Sells, it's a competency, right?
Yes.
Quentin Sells.
Quentin Bell. Not that one.
I've seen. Maybe I'm not sure.
Good morning. Are you Quentin Sells?
Yeah.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani, also has the same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician's certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil, locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the competency.
Right.
With the mental competency with falls.
Right. I think the doctors still
This
think
is
they think you need a little more treatment so that you understand all of your legal proceedings. Okay. All right. You can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge. I think there's another way we can go
Okay,
with this.
I agree.
Next time.
Johnny Segita or Segeda?
I think it's a good one.
Johnny. Johnny what?
Good morning. Are you Johnny Segeda Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here you go, Your Honor.
Mr. Segeda, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison. which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine two things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that. Is that what you want to do? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Segate is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay? You can go back with the bailiff. What about Byron Morris? I have it. Let's do Byron Morris.
Byron Morris. Byron.
We're moving some stuff. Hey. It's all right. Good morning, sir. Are you Byron Jamal Morris?
Yes, it will.
And Mr. Rojas, will your client waive the formal reading of the motion?
It will, Your Honor.
Mr. Morris, in cause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
Not true.
Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, ma'am. True. True.
Count 3 alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court-assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1 and 4. And I'm assuming if there's an officer, even with the public intoxication, it wouldn't be longer than a regular day. We can add it to the end. All right, so we'll set this so that we have time for a couple of witnesses just on a regular Tuesday docket. Anything that you think is important for me to know, make sure you get that to Mr. Rojas, and he'll present it to me on your behalf when you come back.
Yes, ma'am.
Okay, you go back with the bailiff.
Thank you, Robert. Thank you.
Thank you. I should show that it was reset.
Yeah.
Mhm.
I was not asked to teach you, and I'm gonna. I'm sorry.
That's okay. Okay. Let's see. Talking, Mr. Lewis, you've got Avriona Dorsey.
I think I need to sign that, Your Honor.
Okay, I'll call it as soon as she's ready. Do you need, oh, she's already doing another one. How about Kenneth Harrison? Mr. Lewis?
Harrison.
Morning.
Hey.
How are you?
Oh, no, right.
Good morning. Are you Kenneth Harrison? And will your client waive the formal reading of the motion?
He does.
Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first degree felony offense of aggravated robbery. And that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed on or about March 31st of 2026. Is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count 7, let's see, state abandons 4, 5, and 6. Count 7 alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count 8 alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Gerodrick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
your question with the underlying offense, Rob?
I'm just going to go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. When they got caught, one of them fired a shot at the person who confronted them while they were breaking into cars at a parking lot. I put everyone on probation. They've all come back, Josh.
I guess my concern is that there was obviously a gun and a shot in the underlying offense.
I do recall Mr. Harrison not being the shooter. I think we were able to figure out who.
But he's in another gun. I mean, another car with somebody
Yes.
with another gun.
And Mr. Randall's been revoked and sentenced to 8 years. He had
And that's where this courtroom session comes to an end. Judge Raquel West made one thing clear throughout these cases. Every defendant may be given an opportunity, but that opportunity comes with responsibility, whether it's probation, treatment, or a second chance. Violating the court's orders can bring serious consequences. So the question is, will these defendants actually learn from the warnings they received today, or will we see them back in front of Judge Raquel West again? Let us know your thoughts, and if you enjoyed this courtroom breakdown, make sure to like, subscribe, and stay tuned for the next case.